Welcome to the unit on the Commercial General Liability Policy, which is commonly referred to as the CGL. This is one of our larger units of study, so we're going to put the list of our covered topics up on the screen for your quick review, and then we'll get started. Okay then, that was quite a list. I'm sure you will agree, but just like the other units, we'll move right through the material and we'll be done before you know it. The Commercial General Liability Insurance form covers business liability that is not addressed specifically by another policy type. For example, the business auto policy covering the liability for commercial automobile exposures. The CGL covers the insured's premises, operations, completed operations, and products liability exposures. Also consider liability exposures to an insured business can be direct, vicarious, or assumed under contract. The primary policy form for covering these general business hazards is the Commercial General Liability Policy, the CGL, and we'll analyze it in detail in this unit. Other general liability forms for more specific purposes are also briefly discussed. The CGL declarations page, like all deck pages, identifies the named insured and address, states the policy period and premium, and provides miscellaneous information about the insured and the limits of coverage that apply. The CGL, like other ISO policies, has common policy conditions, including a cancellation condition. Keep in mind, our Florida law requires an insurer to state the reasons for a cancellation and to provide a certain number of days of prior notice to allow the insurer to remedy any stated circumstance, pay any premium, and if necessary, find a replacement policy. You can see the list to my right looks very much like many of the other policies' cancellation provisions. Some of the CGL common policy conditions are much the same as the common policy conditions in other policy forms. For example, any change to the CGL must be made by endorsement and only as agreed to by both the insurer and insured. As with other policies, the transfer condition limits the insured's ability to transfer the policy without the written consent of the company. Keep in mind that transfers of CGL policies are so rare that they might as well be excluded. The examination of books and records conditions gives the insurance company the right to audit the insured's books during the policy period and for 3 years after. And the inspections and surveys conditions gives the insurance company the right to inspect, give reports, and make recommendations. Let's now look at the CGL's coverages, starting with Coverage A, bodily injury, and property damage. Coverage A of the CGL coverage form states, "We will pay those sums that the insured becomes legally obligated to pay as damages because of bodily injury or property damage to which this insurance applies." Let's break that simple statement down a bit to its basic terms. For the coverage to respond, the claim must be against someone who has the status of insured. There must be a legal obligation to pay a third party, and that obligation must be for damages. Damages being what a court would assess in monetary terms. Bodily injury being physical harm, including sickness or disease or death resulting therefrom, and property damage being physical injury to tangible property, including loss of use of that property. The phrase "to which this insurance applies" means that coverage is not provided for any and all liabilities, as such coverage will be limited by exclusions and other provisions in the policy. Businesses have many liability exposures, most of which are covered under this section of the CGL coverage form. One of the most important liability exposures for a business is its premises and operations exposures. That is, liability arising out of the business location or its activities at any location. A business may also face liability exposures because of defects in its products or completed operations. The products completed operations exposure includes all BI and PD occurring away from premises the insured owns or rents and arising out of the insured's products or work except products still in the insured's physical possession or work that has not been completed or abandoned. Work means work or operations performed by the insured or on the insured's behalf, including materials, parts, or equipment furnished in connection with the work or operations. Work is typically deemed to be completed at the earliest of one of the following times. 1. When all work called for in a contract has been completed, or 2. When all of the work to be done at one location has been completed, even if the insured has contracted for work at one or more locations, or 3. When partial work has been done and that part of the job has been put to its intended use. And product means any goods or products manufactured, sold, handled, distributed, or disposed of by the named insured or others trading under the named insured's name, or a person or organization whose business or assets the named insured has acquired. In a nutshell, the CGL covers an insured's liability exposures for premises and operations, product liability, and completed operations. As a quick recap, premises and operations covers the exposures tort liabilities that may be imposed upon owners and tenants for the breach of their legal liabilities arising from the ownership, use, occupancy, possession, control, and activities at the insured location. Products liability covers the legal responsibility of a manufacturer, distributor, or retailer to a user or consumer of the product. The liability arises out of the sale, distribution, or manufacture of dangerous, defective, or unsafe products, and the failure of the manufacturer, distributor, or retailer to meet their legal duty with respect to the particular product. If the user or consumer sustains an injury or property damage caused by the product, liability will be imposed. And completed operation liability. Completed operation covers exposures which arise out of work performed by the insured and after the completion of the work. Coverage limitations. As with all other policies, the CGL has coverage limitations. Coverage is for bodily injury or property damage, which is caused by an occurrence which takes place in the coverage territory of the United States, U.S. territories, Puerto Rico, and Canada, including international waters or airspace between each. An occurrence is defined to be an accident, including continuous or repeated exposure to substantially the same general harmful conditions. Accidents are sudden, unexpected events, including exposures to harmful conditions. Interestingly, products liability coverage is on a worldwide basis. Also important is the duty to defend the insured, which is included in the policy, and this duty actually comes before the insurer's duty to indemnify the insured for their legal liability. The duty to defend the insured ends when the policy coverage limits are exhausted. The remaining portion of the insuring agreement for bodily injury and property damage liability deals with how the policy will apply to occurrences and claims depending upon their timing or the coverage trigger. The CGL can be written on an occurrence or claims-made basis. The occurrence form applies to bodily injury or property damage that occurs during the policy period, regardless of any later time at which a claim is made. The claims-made form applies only to a bodily injury or property damage that occurs on or after the retroactive date, and for which the claim is received or recorded by an insured or the company during the policy period. This certainly begs the question, what in the heck is a retroactive date? Answer: a retroactive date is a date listed in a claims-made CGL policy that marks the earliest date of a claims occurrence that will be covered. Retroactive dates are either the same as the policy's inception or a specified date earlier than the policy's inception. In a nutshell, the CGL can be written on an occurrence or claims-made basis And as a quick recap, we'll revisit both forms. The occurrence form applies to bodily injury or property damage claims which occur during the policy period. Get it? Occurrence form equals occurrences during the policy period. Also note, with the occurrence form, there is no requirement that the claim be filed during the policy term in which the bodily injury or property damage took place, only that the loss occurred during the policy term. Compare that with the claims made form, which applies to bodily injury or property damage that occurs on or after the retroactive date. The claims made form applies to a BI or PD that occurs on or after the retroactive date. And the retroactive date basically is an effective date. The claim must be filed, or we might say made, during the policy period. That is, claims made form equals loss occurs after the retroactive date and loss occurs within the policy period, and the claim is filed or made within the policy period. Depending on how often an insured switches policies and what the insured switches to, there is a huge exposure for a coverage gap. To address this exposure, at least in part, the claims made form provides a basic extended reporting period, commonly referred to as BERP. That's right, BERP, B-E-R-P. The basic extended reporting period provides an extension beyond the policy term for the reporting of a claim. Basically, BERP covers gaps caused by canceled or non-renewed policies, or policies renewed with retroactive dates later than the date stated in the prior year's declaration page, or policies renewed with a policy other than a claims-made policy. BERP extends coverage to claims made within 60 days after the policy's expiration, and BERP extends coverage to claims made within 5 years if occurrences were reported within 60 days after the policy's expiration. Once the basic extended reporting period takes effect, the insured is guaranteed the option to purchase supplemental extended reporting period coverage. The insurance industry loves abbreviations, and we refer to the supplemental extended reporting period as SERP. If the insured wishes to acquire the supplemental extended coverage, they must do so in writing within 60 days after the policy's expiration. The effect of this option is to extend the filing of a claim to an unlimited duration. The known loss rule and the modified insuring agreement. The effect of the known loss rule is that an insured cannot insure against a loss that is already known to have occurred. The modified insuring agreement replaces language concerning prior losses to known injury or damage. Thus, an insured would have coverage for a loss they knew had occurred but was not aware of any injury or damage as a result of the loss. I had an insured that owned a women's consignment store, and she brought her dog to work most days. One day, the little dog started barking while a customer was leaving the store, and the customer tripped over a potted plant and fell to the ground. The customer was quite shaken as she lay there on the ground for a few minutes. She may have even been crying. The owner offered to call an ambulance or to take her to the emergency room, but she refused both. This fits right in with the modified insuring agreement. The insured knew of the occurrence, but not if the customer was actually injured. As it turned out, the woman died from the fall. Just kidding. The owner never saw the woman again and never heard from her. Basically, an occurrence without injury or damage. Let's dig in now to some important CGL, bodily injury, and property damage exclusions. As with other policy forms, there is no coverage for intentional injury. Coverage is excluded for any injury or damage which is expected or intended by the insured. By and large, assumed contractual liability is excluded. There are two exclusions to the exclusion. First, if the insured is legally liable notwithstanding the contract, then coverage applies. And secondly, contracts granting immunity spelled out in the policy are not excluded. Most notably, these are leases, sidetrack agreements, and easements. Liquor liability. If the insured is in the alcohol business, they don't have liability coverage in the CGL for serving liquor to 1, intoxicated persons, 2, underage persons, or 3, service to anyone in violation of the law. And as you might guess, the CGL excludes injuries to employees, as workers' compensation insurance is an exclusive remedy to an injured employee. Coverage A also excludes liability coverage for the insured's work, products made and sold, product recall, and/or any defect or delay. Coverage A of the CGL excludes liability for aircraft, automobiles, or watercraft which is owned, operated, loaned to, or rented to an insured. Coverage is also excluded for transporting mobile equipment by an automobile on any roadway. This concludes our review of Coverage A. Please take a quick break and let's reconvene with Coverage B, personal and advertising injury. Personal injury covers injury other than bodily injury arising out of false arrest, detention, imprisonment, malicious prosecution, wrongful entry, libel, slander, and invasion of privacy. Advertising injury covers injury for oral or written libel, slander, or defamation, publication resulting in an invasion of privacy, misappropriation of advertising ideas or style, and infringement of copyright, title, or slogan. And now here we go to Coverage C, medical payments. Coverage C, medical payments, provides coverage to members of the public who sustain injuries caused by accidents on or next to the insured's owned or rented premises. Payment is extended to the injured party irrespective of any legal liability on behalf of the insured. A base limit of $5,000 applies. Keep in mind, MedPay claims must be incurred and reported to the insurance company within 1 year of the date of accident. Now let's talk just a spell about supplementary payments. Supplementary payments in most policies, including the CGL, cover costs related to claims and are payable in addition to the policy limits. Generally, all costs of litigation are covered, including court costs, prejudgment interest, post-judgment interest, and the cost of bonds to release attachments. Additionally, the insured can be reimbursed for expenses incurred at the company's request related to the investigation or defense of a claim, including up to $250 per day for loss of earnings because of time off work. Who is insured? Individuals, partnerships, limited liability corporations, joint ventures, and corporations including their executive officers, directors, stockholders, employees, and all spouses are all considered to be insured under the CGL. As for newly acquired organizations, they are eligible for automatic coverage for up to 90 days. The CGL policy is written with a general aggregate limit, which is the total amount for all Coverage A bodily injury and property damage liability, Coverage B personal and advertising injury, and Coverage C medical payments. The product's completed operations aggregate limit is the most the insurer will pay under Coverage A for injuries or damages related to products and completed operation losses for the policy term. Under the general aggregate limit are sublimits for personal and advertising injury, products and completed operations, fire legal liability, and medical payments. Limits in a policy are listed pretty much as you see them to my right. Sometimes more than one policy and set of limits applies to a claim. The other insurance provisions in the conditions section of the CGL states that all applicable insurance policies not defined as excess are primary. Policies which are primary share claims on an equal shares or pro rata basis. And generally speaking, the claims made form is excess over any other policy that is also not claims made. The aforementioned coverages and limits cover most business exposures. There are in fact general liability forms which cover specialized purposes, and as you may have guessed, we're going to review 4 of the more specialized policies, starting with the OCP policy form. The Owners and Contractors Protective Liability Form, also known as OCP, protects the insured against claims for bodily injury and property damage arising out of work performed by independent contractors working on the insured's behalf. There are two general uses of the OCP. The first is an insured owner insuring the operations exposure of a hired general contractor. And the second exposure is when a general contractor insured insures the operation exposure of work performed on the insured's behalf by independent subcontractors. In the latter case, the OCP even protects the general contractor insured for their negligent supervision. The Liquor Liability Coverage Form provides coverage for those who are in the business of manufacturing, distributing, selling, serving, or furnishing alcoholic beverages. The Products Completed Operations Liability Coverage Form provides a monoline form solely for the product's completed operations exposure and is usually purchased when an underlying CGL policy excludes products and completed operations coverage. The Pollution Liability Coverage and Pollution Liability Policy Form provide coverage for bodily injury and property damage from a pollution incident. A pollution incident is defined as an emission of pollutants onto land, the atmosphere, or water, causing environmental damage. The basic pollution liability form is cheaper, but does not cover the cost of any environmental cleanup. This can be remedied by purchasing the costlier broad form, which includes the cost of cleanup. Okay folks, I call this the home stretch. We have several policy types left, which are really interesting, and I apologize that we may only be introducing them to you in this course. I encourage you to explore each of these further. Now, in no particular order, here they are: excess and umbrella liability, professional liability, farm liability, employment-related practices liability, and we finish this unit with cyber liability. Sometimes the liability limits provided by a policy are insufficient for the insured's business. Two coverage forms are used to provide the additional amounts needed: excess liability and umbrella policies. If an insured had a CGL policy with $1 million per occurrence coverage and $2 million of aggregate coverage and a $1 million umbrella, then the insured would actually have up to $2 million of liability coverage in the event of a liability loss. There are two basic types of excess liability policies: follow form and standalone. Both require underlying policies to be in effect, and neither will provide any coverage not provided by an underlying policy. The follow form excess liability policy provides coverage in excess of underlying limits, applying the exact same coverages, conditions, provisions, and exclusions as the underlying policy. Now, contrast follow form with the standalone excess liability policy, which provides coverage in excess of underlying limits, but does not apply the same conditions, provisions, or exclusions as the underlying policies. An umbrella policy provides additional liability amounts and often provides additional coverage not included in the underlying policies. Additional coverages may include personal injury, watercraft liability, and some professional activities. When the umbrella policy does not have underlying coverage, the umbrella becomes the primary coverage protecting the insured. If this occurs, the insured is responsible for an initial amount of the claim, like a deductible of sorts. This first dollar responsibility is called the insured's self-insured retention. Professional liability insurance covers an insured's liability arising from performing or failing to perform professional services which lead to injury or damage to a third party. In a nutshell, professional liability insurance covers damages arising from a breach of duty of care required by a professional under the same or similar circumstances. Physicians, surgeons, and dentists' professional liability insurance is commonly referred to as PS&D, and it covers the legal liability resulting from medical incidents. Medical incidents are generally defined as the furnishing of medical or dental services by the insured, the insured's employee, or anyone else under the personal direction, control, or supervision of the insured. The insurance company has the typical duty to defend the insured against claims, and defense costs are payable in addition to the policy limits. Often the injured party will sue the doctor and also the facility where the alleged wrongdoing and injury took place. Hospital professional liability covers the liability of the insured facility or organization for medical incidents, which, in this form, again are defined as acts or omissions in the furnishing of professional healthcare services. Look to my right and you can see other medical professions which can be covered by an endorsement to the PS&D policy. Lawyers' professional liability provides coverage for acts or omissions of the insured in the rendering of professional services as a lawyer. Coverage applies to the insured in the fiduciary capacity as an administrator, conservator, executor, guardian, or trustee. The lawyer's professional liability policy excludes claims arising out of dishonest, fraudulent, criminal, or malicious acts or omissions of the insured or any insured employee. Interestingly, claims expenses are part of the liability limits in the lawyer's professional liability coverage form, not in addition to them. Again, worth repeating, claims expenses, including legal defense, are part of the liability limits. The farm liability coverage form provides coverage for bodily injury or property damage arising out of commercial farming operations and/or personal activities of the farmer. It covers personal and advertising injury and provides medical payments coverage without regard to liability. Let's look at two important farm liability endorsements: the custom farming endorsement and the farm employer's liability endorsement. First, the custom farming endorsement covers liability for the insured's paid farming operations for another farm operation, and the farm employer's liability medical payments endorsement covers liability and medical payments coverage to injuries to farm employees. Employment Practices Liability Insurance is commonly referred to as EPL or EPLI. EPLI provides coverage to employers against claims made by employees alleging unlawful discrimination, wrongful termination, and harassment. The policy has a single limit of insurance, which includes both damages and defense expenses. Additionally, there is an insured co-payment provision designed to discourage moral and morale hazard by the insured. The co-payment provision requires the insured to share in the cost for both damages and legal defenses. The EPLI policy is written on a claims-made form, and an extended reporting period is available by endorsement for 3 years at an additional charge. The EPLI policy has some significant exclusions, such as an exclusion for criminal, fraudulent, or malicious acts of the insured. There is no coverage for the insured's acts that are in violation of laws applicable to employers, and there is no coverage for the insured's failure to comply with the Americans with Disability Act. But there is coverage for all of the big federal laws like Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the Equal Pay Act, the Pregnancy Discrimination Act, and the Family Medical Leave Act. Here's a big one: sexual harassment. Keep in mind, there is no coverage for the insured who commits the sexual harassment, but there is coverage for the vicarious liability of the employer insured. Coverage is excluded for injuries to employees who are striking or injured during a lockout, and coverage is excluded for employment terminations or relocations due to business decisions. Intentional acts of the insured for discrimination or coercion are excluded, as are retaliatory actions against whistleblowers. The EPLI policy specifically defines defense expenses, discrimination, injuries, sexual harassment, and suit. Defense expenses are the legal fees and associated costs in defense of claims brought against the insured for which the policy provides coverage. Discrimination is defined as a violation of a person's civil rights with respect to that person's race, color, national origin, religion, gender, marital status, age, sexual orientation or preference, physical or mental condition, or any other protected class or characteristic established by a federal, state, or local law. Employment practice injuries are defined as the refusal to employ, termination, demotion, or failure to promote, negative evaluation, reassignment, discipline, defamation or humiliation based on discrimination, coercing the person to commit an unlawful act or omission within the scope of their employment, work-related sexual harassment, other work-related verbal, physical, mental, or emotional abuse because of race, color, national origin, gender, marital status, age, sexual orientation or preference, physical or mental condition, or any other protected class or characteristic. Sexual harassment includes unwelcome sexual advances, verbal, visual, or physical conduct of a sexual nature if that conduct affects or interferes with another's employment performance or creates an intimidating, hostile, or offensive working environment. And a suit is defined as a civil proceeding alleging damages including arbitration, alternative dispute resolutions, or administrative hearings conducted by a government agency. Cyber liability insurance. Alas, we are at the end of our review concerning commercial general liability, but no review would be complete without at least a cursory look at the new risk of cyber liability. Cyber liability insurance covers the risk of collecting and storing secured data from clients. Policies cover intentional and unintentional loss from liability, including the repair or replacement of the computer systems and the cost of notifying clients and lawsuits.